So let's get started. AB 1482, the Tenant Protection Act of 2019, also known as the RCJC. This is a super important law that kind of started the whole statewide regulation of rents and evictions and capping all of that. Prior to this, certainly different cities have had their rent caps and eviction laws, but this is where it kind of started at the state level. So what does AB 1482 talk about? AB 1482 limits rent increases to consumer price index, CPI plus 5% with a max at 10%. So ultimately, we can only raise the rent at maximum 10%. So which CPI? What month? Big questions that are not easily answered just on a quick Zoom. But yeah, it has to do with, in the law, it talks about which month and which CPI. Part of the problem is the CPI that it requires is April, but they don't even do an April CPI for Riverside. So the more questions than are answered in that. We have consulted with our lawyers and we do what we do, but definitely will need to consult with lawyers to figure out what to do in that case. Any idea what our maximum rent increase is right now for Riverside? Any ideas? Let's throw in the chat real quick. What do you think? What do you think is our maximum? If CPI plus 5% is our maximum, capped out at 10%, what do you think? Any ideas? In the chat, 5%, so 9.2. All right, you're cheating, Rebecca, 9.2. You better know. You're pretty darn close, but not quite. Mimi's at 10%, close. The actual maximum for Riverside right now is 9.3%. So Rebecca was pretty darn close. Yeah, so our CPI last year was 4.3. So plus 5, that's a max increase of 9.3. All right, so that's kind of the parameters that we're working within, that we have to stay within. The other half of the AB 1482 is the evictions, at fault versus no fault, and relocation assistance. There are specific at fault, meaning the tenant is at fault for being evicted. Actually, before I go into that real quick, what does that word eviction even mean? In my mind, eviction means that we're going on to court, right? We're kicking them out. We're going to court. We filed court proceedings. That is an eviction. Actually, that's not an eviction. That's an unlawful detainer. Eviction is any time that we are talking about asking a tenant to move out. So that could be for good reasons, where we're asking them to move out because we want to sell the house, we want to do whatever, something different, or they're not paying the rent. It's all considered evictions, right? So we've got at fault. At fault is that they've done something wrong. They aren't paying the rent. They are in breach of a material term in the lease. They're committing a nuisance. They're committing waste. And these nuisance and waste are specific legal terms. To me, a nuisance is they're making too much noise or their dog barks or something. That isn't part of the legal term of a nuisance. So these words mean things. The tenant refusal to sign a new lease extension under similar terms, a few other things that they are doing or not doing that can cause an eviction. If we're evicting them under that scenario, not a problem. We can evict them and get them out through the normal court process. However, now, in the past, before this law went into effect, we could ask somebody to move out for any reason. We did not have to have a reason to ask them to move out. We could ask them to move out because they're ugly and we don't like them anymore, but not anymore. There's a short list of no fault reasons that we can ask a tenant to move out. One of which, owner intends to occupy the property. So if you or a particular group of relatives stated in the law want to move into the property, we can ask them to move. We can, if the property is being taken off of the rental market, that would be like if we were going to sell it or something along those lines. If a government agency declares the property not habitable and they have to get out, then they can get out, but it is at a no fault of theirs. And intent to demolish or substantially remodel the property. And there's significant restrictions on what that means. So we do have some ways that we can get them out that's no fault. But if it's a no fault eviction, then we've got some more hoops to jump through. And the big one is that we've got to give them 1 month's free rent, or actually cash equal to 1 month's rent within 15 days of giving them that notice. So we've got some very specific parameters that we have to work within, unlike prior to 2020 when this went into effect, how we can get somebody out of a property. So that's 1482, AB 1482. Now, exceptions. There are some pretty important exemptions in this law. And bottom line, that comes down to what the house looks, or the property looks like, right? If the property is less than 15 years old, it's exempt. All of these exemptions are only exempt if you told the tenant at move-in that you were exempt. So if you didn't tell them, then you don't have the exemption. But if it's less than 15 years old, if it's an owner-occupied unit, like you're renting out a room or something like that, single-family residences are exempt for the most part. So single-family residences, that's most of what WSR does. So you're probably exempt. But the notice of exemption must be given before you're trying to get them out, right? So again, if WSR is handling your property, we're taking care of this. We're giving them those exemptions, notice of exemptions when they moved in. We gave them the notice of exemption back in 2020 if they are older than that, when this law went into effect. So you should be covered there if you are exempt. Excellent. So that's 1482.